to NPC, an educator at ClearIAS. Let's start with today's prelims question challenge.
Question number 1. Which of the following committees recommended the establishment of the institution of Lokpal and Lokayukta? Option A, Ashok Mehta Committee. Option B, Appleby Committee. Option C, Gorwala Committee. And option D, Administrative Reforms Commission. Question number 2. Which of the following are major features of the institutions of Lokpal and Lokayukta as recommended by the Administrative Reforms Commission? 1. They should be demonstrably independent and impartial. 2. They should compare with the highest judicial functionary in the country. 3. They should be directly accountable to Parliament. 4. Their appointments should as far as possible be non-political. Select the correct answer by using the codes given below. Option A 1, 2, 3 and 4. Option B 1, 2 and 4. Option C 2 and 3. And option D 3 and 4. Question number 3. The institution of Lokayukta was first established in option A Kerala, option B Tamil Nadu, option C Maharashtra and option D Odisha.
Now it's time for today's mains questions.
Question number 1. Critically examine the issues involved in the functioning of Lokpal. Does it dispute with the mandate of elected representatives? Suggest methods to make Lokpal effective with least interference with the government affairs. Question number 2. Define and distinguish between the terms Lokayukta and Lokpal in the Indian context. Also, mention about its relevance.
Comment your answers of both the prelims and mains questions in the comment box. Today's questions are related to the Lokpal and Lokayuktas. These topics come under
Paper 3 of the UPSC Mains syllabus, that is General Studies 2, Governance, Constitution, Polity, Social Justice and International Relations. Under it, statutory, regulatory and various quasi-judicial bodies.
the Lokpal is the National Anti-Corruption Ombudsman and Lokayuktas are its state-level equivalents. Let's discuss these in detail now under the heads.
Need for Lokpal and Lokayukta. Historical background. History of Lokpal and Lokayukta. Commissions that recommended Lokpal and Lokayuktas. Lokpal and Lokayuktas Amendment Bill 2016. Structure and composition of Lokpal. Selection process. Branches of Lokpal. Jurisdiction and powers of Lokpal. The procedure of inquiry. Recent changes in filing complaints. Limitations of Lokpal. Lokayuktas in states. Structure of Lokayukta. Conclusion.
First of all, let's see the needs for institutions like Lokpal and Lokayukta.
Currently, we are in a situation where the authority of the executive has been deteriorated significantly. All executive institutions, because of various reasons, are losing credibility. Maladministration is like a termite which slowly erodes the foundation of a nation and hinders administration from completing its task. Corruption is the root cause of this problem. Most of the anti-corruption agencies are hardly independent. Even Supreme Court has termed CBI as a caged parrot speaking in its master's voice. Many of these agencies are advisory bodies without any effective powers and their advice is rarely followed. There is also the problem of internal transparency and accountability. Moreover, there is not any separate and effective mechanism to put checks on these agencies. In this context, an independent institution of Lokpal has been a landmark move in the history of Indian polity which offered a solution to the never-ending menace of corruption. Now let's know the historical background of these institutions. In 1809, the institution of Ombudsman was inaugurated officially in Sweden. In the 20th century, Ombudsman as an institution developed and evolved most significantly after the Second World War. New Zealand and Norway adopted this system in the year 1962 and it proved to be of great significance in spreading the concept of the Ombudsman. In 1967, on the recommendations of the Wyatt Report of 1961, Great Britain adopted the institution of Ombudsman and became the first large nation in the democratic world to have such a system. In 1966, Guyana became the first developing nation to adopt the concept of Ombudsman. Subsequently, it was further adopted by Mauritius, Singapore, Malaysia and India as well. Now let's see the history of Lokpal and Lokayukta in India. In India, the former Law Minister Ashok Kumar Sen became the first Indian to propose the concept of constitutional ombudsman in Parliament in the early 1960s. The term Lokpal and Lokayukta were coined by Dr. L.M. Singhvi. It comes from a Sanskrit word that means protector of people. In 1966, the first Administrative Reforms Commission recommended the setting up of two independent authorities at the central and state level to look into complaints against public functionaries, including members of parliament. In 1968, Lokpal Bill was passed in Lok Sabha but lapsed with the dissolution of Lok Sabha, and since then it has lapsed in the Lok Sabha many times. In 1971, Maharashtra became the first Indian state to establish a Lokayukta and to oversee corruption in various agencies. India also signed the United Nations Convention Against Corruption. Till 2011, 8 attempts were made to pass the Lokpal Bill, but all met with failure. In 2013, both houses of parliament enacted the Lokpal and Lokayuktas Bill 2011. The Lokpal and Lokayukta Act 2013 got the approval of President on 1st January 2014. It came into force on 16th January 2014. It was revised in 2016 to close a minor gap. Meetings of the Selection Committee of Lokpal and Lokayukta Act 2013 were held in March and April 2018 following the intervention of the Supreme Court. In September 2018, the government had constituted a search committee headed by former Supreme Court Judge Justice Ranjana Prakash Desai. On March 19, 2019, retired Justice Pinaki Chandra Ghosh was appointed as India's first Lokpal along with 8 judicial and non-judicial members. In March 2020, Lokpal announced rules and a structure for registering complaints. Here is a list of commissions that recommended Lokpal and Lokayuktas. In 1966, the first Administrative Reform Commission advocated the establishment of two independent authorities, one at the national level and the other at the state level, to investigate complaints against public officials, including members of parliament. Morarji Desai was in charge of this commission. In 2002, the Commission to Review the Working of the Constitution, headed by M.N. Venkatachalaya, recommended the appointment of the Lokpal and Lokayuktas. Also recommended that the Prime Minister be kept out of the ambit of the authority. In 2005, the Second Administrative Reform Commission, chaired by Veerappa Moily, recommended that the office of Lokpal should be established without delay. In 2011, the well-known Anna Hazare movement for Lokpal was launched. In 2011 itself, the government formed a group of ministers chaired by Pranab Mukherjee to suggest measures to tackle corruption and examine the proposal of a Lokpal bill. Next is the structure and composition of Lokpal. It is a statutory body without any constitutional backing. It consists of one chairman and a maximum of 8 members. The chairperson should be either the former Chief Justice of India or the former Judge of Supreme Court or an eminent person with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in the matters relating to anti-corruption policy, public administration, vigilance, financing including insurance and banking, law and management. Out of the maximum 8 members, half will be judicial members. Minimum 50% of the members will be from scheduled caste or scheduled tribes or other backward caste or minorities and women. The judicial member of the Lokpal should be either a former judge of Supreme Court or a former Chief Justice of a High Court. Non-judicial member should be an eminent person with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in the matters relating to anti-corruption policy, public administration, vigilance, finance including insurance and banking, law and management. The term of office for chairman and members will be 5 years or till the age of 70 years. The members are appointed by the President on the recommendation of the Selection Committee. Salaries, allowances and service conditions of the Lokpal chairperson will be the same as that for the Chief Justice of India. For other members, these will be the same as that for a judge of the Supreme Court. Now let's see how the selection process is being done. For selecting the chairperson and the members, the Selection Committee constituted a search panel of at least 8 persons. Under Lokpal Act of 2013, the Department of Personnel and Training is supposed to put together a list of candidates interested to be the chairperson or members of the Lokpal. The list would then go to the proposed 8-member search committee, which would shortlist the names and place them before the selection panel headed by the Prime Minister. The selection committee is composed of the Prime Minister, who is the chairperson, Speaker of Lok Sabha, Leader of Opposition in Lok Sabha, Chief Justice of India or a judge nominated by him or her, and one eminent jurist. The selection panel may or may not pick names suggested by the search committee. After the selection of members, the Lokpal will set about creating its various wings, such as Inquiry Wing, which is headed by the Director of Inquiry. This conducts preliminary inquiry into any offence allegedly committed by a public servant punishable under the Prevention of Corruption Act 1988. And Prosecution Wing, which is headed by the Director of Prosecution. It is to prosecute public servants in relation to any complaint by the Lokpal under this Act. Lokpal will have two primary branches through which it would carry out its tasks. The administrative branch will be led by a secretary to the Government of India and will include the following departments. An officer not lower than the rank of Additional Secretary to the Government of India will lead the inquiry or investigation branch. The prosecution wing would be led by an officer with the rank of Additional Secretary to the Government of India. The second one is the judicial branch, which will be led by a judge of appropriate rank who will help the Lokpal in carrying out their judicial duties. Next is the jurisdiction and powers of Lokpal. The jurisdiction of Lokpal includes Prime Minister, Ministers, Members of Parliament, Group A, B, C and D officers and officials of central government. It shall apply to public servants in and outside India. It also includes the Lokpal on members under the definition of public servant. The chairperson, members, officers and other employees of the Lokpal while functioning under the provisions of this Act shall be deemed to be public servants. It also includes any person who is or has been in charge of anybody or society set up by Central Act or any other body, financed or controlled by central government, and any other person involved in act of abetting, bribe giving or bribe taking. But the armed forces do not come under the ambit of Lokpal. A complaint under this Act shall only relate to a period during which the public servant was holding or serving in that capacity. The Lokpal will have the power of superintendence and direction over any investigation agency, including CBI, for cases referred to them by the ombudsman. As per the Act, the Lokpal can summon or question any public servant if there exists a prima facie case against the person even before an investigation agency has begun the probe. Any officer of the CBI investigating a case referred to it by the Lokpal shall not be transferred without the approval of Lokpal. An investigation must be completed within 6 months. However, the Lokpal or Lokayukta may allow extension of 6 months at a time provided the reasons for the need for such extension are given in writing. Special courts will be instituted to conduct trials on cases referred by Lokpal. Next is about the procedure of inquiry. The Lokpal may, after receiving a complaint against any public servant, order a preliminary inquiry which has to be completed within 90 days. After receiving the report of the preliminary inquiry, the Lokpal may order an investigation by any agency or departmental proceedings. He or she may also take any other appropriate action by the competent authority, or it can order closure of the proceedings. Next is Lokpal and Lokayuktas Amendment Bill 2016. It was passed by Parliament in July 2016. It amended the Lokpal and Lokayukta Act 2013. It enables the leader of the single largest opposition party in Lok Sabha to be a member of the selection committee in the absence of a recognized leader of opposition. It also amended Section 44 of the 2013 Act that deals with the provision of furnishing of details of assets and liabilities of public servants within 30 days of joining the government service. It replaces the time limit of 30 days. Now, the public servants will make a declaration of their assets and liabilities in the form and manner as prescribed by the government. It also gives an extension of the time given to trustees and board members to declare their assets and those of their spouses in case of these are receiving government funds of more than rupees 1 crore or foreign funding of more than 10 lakh rupees. Now let's know about the recent changes introduced in filing complaints. The complaint may ordinarily be made in English electronically in manner as laid down by Lokpal by post or in person. The Lokpal shall not keep the said complaint received electronically as pending if the same is complete in all respects. Lokpal may also entertain a complaint in any of the 22 languages referred to in the 8th schedule of the Constitution. It shall dispose of the complaint within 30 days. It will protect the identity of the complainant or the public servant complained against until the conclusion of the inquiry or investigation. This will smoothen the process by enabling the body with structured disposal of cases in a speedy manner. Next is about the limitations of Lokpal. In case of complaints against Prime Minister, the Lokpal shall inquire or cause an inquiry to be conducted into the allegations of corruption. But the Act does not allow Lokpal inquiry if the allegation against the Prime Minister is related to international relations, external and internal security, public order, atomic energy, and space. Also, complaints against the Prime Minister are not to be probed unless the full Lokpal bench considers the initiation of an inquiry and at least two-thirds of the members approve it. Such an inquiry against the Prime Minister, if conducted, is to be held in camera. If the Lokpal concludes that the complaint deserves to be dismissed, the records of the inquiry are not to be published or made available to anyone. The Lokpal's selection process is skewed because there was no guidelines for deciding who is an eminent jurist or a person of integrity. No proper procedure for appealing Lokpal's actions. The Lokpal and Lokayukta Act also stipulates that no complaint against corruption can be filed until a period of 7 years has passed from the date on which the alleged offence was committed. The appointing committee for Lokpal is made up of political party representatives who try to sway Lokpal's choices. Omission of the judiciary from its purview is one of the most serious problems. There is no legal basis for the Lokpal's rulings and there are no effective methods for contesting them. No complaints can be filed against a public servant under the Army Act, Navy Act, Air Force Act and the Coast Guard Act. The 2013 Act did not provide concrete immunity to the whistleblowers. Lokpal is not given any constitutional backing. Lokpal cannot suo motu proceed against any public servant. The Act emphasizes on form of complaint rather than substance. Heavy punishment for false and frivolous complaints against public servants may deter complaints being filed to Lokpal. Anonymous complaints are not allowed. People can't just make a complaint on plain paper and drop it in a box with the supporting documents. Legal assistance will be provided to public servant against whom the complaint is filed. Next is about Lokayuktas in states. Lokayukta is the state equivalent of the central Lokpal. It aims to deal with charges against their own officials. As per the Lokpal and Lokayukta Act of 2013, the state will have to institute Lokayukta within 1 year of the commencement of the Act. Many states had established Lokayukta as a statutory entity with a definite tenure even before the Lokpal and Lokayuktas Act of 2013 was enacted. Some states, however, are without a Lokayukta even after the 2013 Act. The Supreme Court recently directed these states to take steps for appointment of Lokayukta. The structure of Lokayukta is not the same in all the states. Some states like Rajasthan, Karnataka, Andhra Pradesh and Maharashtra have created the Lokayukta as well as UPSC. States like Bihar, Uttar Pradesh, Himachal Pradesh have created only the Lokayukta. Other states like Punjab and Odisha have designated officials as Lokpal. This pattern was not suggested by the Administrative Reform Commission in the states. The Lokayukta and UPSC are appointed by the governor of the state. While appointing, the governor in most of the states consults the High Court Chief Justice and the leader of opposition in state legislative assembly. Once appointed, Lokpal and Lokayukta cannot be dismissed nor be transferred by the government and can only be removed by passing an impeachment motion. Now comes the jurisdiction of Lokayuktas. There is no uniformity regarding the jurisdiction of Lokayukta in all the states. The Chief Minister is included within the jurisdiction of Lokayuktas in the states of Himachal Pradesh, Andhra Pradesh, Madhya Pradesh and Gujarat. The Chief Minister is excluded from its purview in the states of Maharashtra, Uttar Pradesh, Rajasthan, Bihar and Odisha. Ministers and higher civil servants are included in almost all the states. Maharashtra has also included former ministers and civil servants. Members of state legislature are included in the states of Andhra Pradesh, Himachal Pradesh, Gujarat, Uttar Pradesh and Assam. The authorities of the local bodies, corporations, companies and societies are included in the jurisdiction of the Lokayukta in most of the states. The Lokayukta presents annually to the governor of the state a consolidated report on its performance. The governor places this report along with an explanatory memorandum before the state legislature. The Lokayukta is responsible to the state legislature. He takes the help of the state investigating agencies for conducting inquiries. He can call for relevant files and documents from the state government departments. The recommendations made by the Lokayukta are only advisory and not binding on the state government. And finally, conclusion. The institution of ombudsman must be strengthened in respect of functional autonomy and workforce availability to fight against corruption. The government should focus on eliminating the root causes of corruption because of which the general public is demanding a Lokpal. There should be complete transparency when nominating a Lokpal and Lokayuktas, as it will increase the chances for the right person to be appointed.
We have discussed almost everything that you need to know about Lokpal and Lokayuktas. Now, see the questions once again.
Question number 1. Which of the following committees recommended the establishment of the institution of Lokpal and Lokayukta? Option A, Ashok Mehta Committee. Option B, Appleby Committee. Option C, Gorwala Committee. And option D, Administrative Reforms Commission. Question number 2. Which of the following are major features of the institutions of Lokpal and Lokayukta as recommended by the Administrative Reforms Commission? 1. They should be demonstrably independent and impartial. 2. They should compare with the highest judicial functionary in the country. 3. They should be directly accountable to Parliament. 4. Their appointments should as far as possible be non-political. Select the correct answer by using the codes given below. Option A 1, 2, 3 and 4. Option B 1, 2 and 4. Option C 2 and 3. And option D 3 and 4. Question number 3. The institution of Lokayukta was first established in option A Kerala, option B Tamil Nadu, option C Maharashtra and option D Odisha. Question number 1. Critically examine the issues involved in the functioning of Lokpal. Does it dispute with the mandate of elected representatives? Suggest methods to make Lokpal effective with least interference with the government affairs. Question number 2. Define and distinguish between the terms Lokayukta and Lokpal in the Indian context. Also, mention about its relevance.
I hope everyone is now able to answer these questions. That's it for today. See you with another set of questions from a new topic in the next video. If you like this video, please comment, subscribe our channel and support us. Thank you.